Part I, Foundations and Legal Framework, specifically for Chapter 1, Introduction to Public Procurement in Oman, based on your provided index. Part I, Foundations and Legal Framework. Chapter 1, Introduction to Public Procurement in Oman. Chapter Overview. This chapter serves as the foundational entry point into the world of Omani public procurement. It establishes why the tender process is a critical instrument of national policy, outlines the core ethical pillars that govern it, and provides clear definitions of the essential terminology that will be used throughout the encyclopedia. Understanding this chapter is crucial for grasping the strategic importance and operational rules of the system. 11. The economic and strategic role of public tenders. Public procurement, often referred to as government tendering, is far more than a simple administrative function of buying goods and services for the state in the Sultanate of Oman. It is a powerful strategic tool for achieving national economic and developmental goals. Driver of national development, infrastructure development. Public tenders are the primary mechanism for building and maintaining the nation's critical infrastructure: roads, ports, airports, schools, hospitals, and utilities. These projects form the backbone of the economy and improve the quality of life for citizens. Economic stimulus. Government spending through tenders injects significant capital into the economy. It creates demand across various sectors, from construction and manufacturing to IT and professional services, stimulating business activity and growth. Instrument of fiscal policy. Tenders ensure that public funds, derived from state revenues, including oil and gas, are allocated efficiently and effectively. The competitive process aims to secure the best possible value for money, maximizing the return on investment for the nation and ensuring responsible stewardship of public finances. Catalyst for private sector growth. The Omani government is one of the largest consumers in the market by awarding contracts to private companies, both local and international. It sustains businesses, fosters entrepreneurship, and encourages the development of a robust and competitive private sector. This is a key pillar of Oman's economic diversification plans, such as those outlined in Vision 2040. Promotion of national strategic objectives. Omanization. Tender documents often include requirements for employing and training Omani nationals, directly supporting national workforce development and reducing unemployment. In-country value ICV, a cornerstone of Omani policy. ICV provisions in tenders mandate that a certain percentage of the contract's value must be spent within the Sultanate. This encourages foreign companies to partner with local SMEs, transfer knowledge and technology, and establish local manufacturing and service facilities, thereby retaining wealth within the country. 12 Key principles: transparency, competition, equality, and efficiency. The entire Omani public procurement system is built upon 4 interdependent and non-negotiable principles, designed to ensure integrity, fairness, and optimal outcomes. Transparency, meaning, the process must be open, clear, and accessible to all potential bidders. There should be no hidden criteria or preferential treatment application in Oman. This is achieved through the mandatory publication of tender opportunities in the official gazette and on government platforms, public bid opening ceremonies, clear and detailed tender documents, and the requirement to provide reasoned feedback to unsuccessful bidders upon request. Competition, meaning, the process must be designed to attract multiple qualified bidders. Competition is the engine that drives innovation, improves quality, and lowers prices. Application in Oman. The default method is an open tender advertised to the public. Restrictions on competition, e.g., limited tenders, direct awards, are only permitted under strict conditions defined in the tender law, Royal Decree 36/2008, such as extreme urgency or the need for specialized expertise. Equality, fair treatment, meaning, all bidders must be treated equally and without discrimination. They must have access to the same information and be judged by the same criteria. Application in Oman. This principle ensures a level playing field. It prohibits any favoritism and mandates that all bidders receive identical tender documents and any subsequent clarifications, addenda. Evaluation committees must apply the pre-disclosed criteria objectively to every single bid. Efficiency, economy, meaning, the process must not only be fair but also effective. It aims to achieve the desired outcome, quality goods, services, or works, at the best possible price, within a reasonable time frame, and with minimal administrative cost. Application in Oman, this principle is embedded in the strict timelines for each stage of the tender process, the requirement for precise technical specifications to avoid disputes, and the fundamental rule of awarding the contract to the lowest valid bid that meets all technical and legal requirements, ensuring optimal use of public funds. 13 Definitions of key terms. Establishing a common language is essential. Below are foundational definitions as commonly understood within the context of Omani legislation. Tender, the entire process through which the government invites bids for a project, evaluates them, and awards a contract. It also refers to the formal document package issued by the government outlining the terms, conditions, and specifications for the project bid, or a formal offer submitted by a prospective contractor, supplier, or consultant in response to a tender invitation. It comprises both the technical proposal and the commercial, priced offer. Bidder, any natural or legal person, company, firm, etc., that submits a bid in response to a tender. Contractor, a bidder who is awarded a contract, typically for execution of works or construction projects. Supplier, a bidder who is awarded a contract for the supply of goods, materials, or equipment. Consultant, a bidder who is awarded a contract for the provision of intellectual or professional services, such as design, engineering, supervision, or management. Consultancy. Tender board, the Supreme Central Committee, often at the ministerial level, tasked with overseeing the tender process, reviewing recommendations, and granting final approval for major contract awards, as stipulated by law. Tender committee, a committee formed within a specific government unit, e.g., a ministry, to manage its tender processes, conduct evaluations, and make recommendations to the tender board or the unit's head. In-country value, ICV, a strategic national policy that measures the economic value retained within the Sultanate through a project. It includes spending on local workforce, goods, services, and investments in local capacity development. Chapter 2, the Governing Legal Framework. Chapter Overview. This chapter delves into the core legal instruments that constitute the backbone of public procurement in Oman. Understanding this hierarchy of laws, their scope, and their interaction with other legislation is fundamental for any entity participating in or administering public tenders. Compliance is not optional, it is a mandatory requirement enforced by a clear regulatory structure. 21 The Tender Law, Royal Decree No. 36/2008, issuing the Tender Law, and its amendments. Nature and authority. Royal Decree No. 36/2008 is the primary and supreme legislation governing public tendering in Oman. As a royal decree, it carries the highest authority in the regulatory hierarchy for this domain. It establishes the fundamental principles, rules, and procedures that all government entities must follow. Key provisions. The law itself is a framework document that outlines the establishment, composition, and powers of the tender board, the different types of tender, open, limited, direct order, etc., and the strict conditions under which each can be used. The general stages of the tender process from announcement to award. Rules for the formation and operation of tender committees within ministries. Guidelines for bid bonds and performance guarantees. The principle of awarding to the lowest valid bidder. Procedures for handling objections and grievances from bidders. Penalties for violations by bidders or government employees. Amendments. The law is a living document. It has been amended by subsequent royal decrees, e.g., to change the financial thresholds for tender board approval, to incorporate new concepts like in-country value, or to streamline procedures. Any practitioner must ensure they are referring to the most updated, consolidated version of the law. 22 The executive regulations of the tender law. Purpose and function. If the tender law is the constitution, the executive regulations are the detailed bylaws and procedural manual. They provide the necessary granularity to implement the broader principles stated in the law. They are typically issued via a ministerial decision. Detailed guidance. The regulations provide explicit instructions on nearly every operational aspect, including the precise format and content of tender documents, model forms, and contracts. Detailed procedures for bid evaluation, technical and financial, calculation methods and caps for bid bonds and performance securities. Step-by-step processes for handling variations, change orders, and extension of time requests detailed rules for the evaluation of consultancy services, where price is not the sole criterion. Documentation requirements for each stage of the process, e.g., minutes of bid opening, evaluation reports, -23 application scope, government units, public authorities, and companies. The tender law does not apply universally to every organization in Oman. Its application is specifically defined. Government units, this is the primary domain. It includes all ministries, ministerial level entities, government authorities, and public administrations. They are strictly bound by the law. Public authorities and institutions, these are state-owned entities established for a public service or economic purpose. They are generally required to follow the tender law, though their founding statutes may specify certain modifications. Companies with government shareholding, this is a critical and often nuanced area. The law applies to companies where the government owns 100% of the share capital. Companies where the government owns 51% or more of the share capital. Companies where the government owns less than 51% but has a controlling interest or has provided a financial guarantee for the project. These companies often adopt procurement bylaws that are based on the tender law but may have tailored procedures for greater commercial flexibility, especially for their non-government related projects. 24 Interaction with other Omani laws. The tender law does not operate in a vacuum. It intersects with several other key Omani laws, creating a complex legal web. The commerce law governs general commercial contracts, agency relationships, and the legal status of companies. Provisions from the commerce law can fill gaps not covered in the specific tender contract. The tax law, successful bidders are subject to Omani corporate income tax. Understanding tax liabilities is a critical part of financial bidding. Withholding tax on payments to non-residents is also a key consideration. The labor law mandates compliance with Omani labor regulations, including wages, working hours, safety standards, and most importantly, Omanization quotas. This is a non-negotiable requirement for any contractor. The law for protection of public funds imposes severe criminal and administrative penalties on government employees and contractors for any actions that squander or misuse public money, including corruption, collusion, or fraud in the tender process. The law of arbitration, many government contracts include arbitration clauses for dispute resolution. The arbitration process is governed by the separate law. 25 The role of the Oman Authority for Public Services Regulation, APSR, evolution of role. Historically, the Tender Board was the central overseer. However, as part of Oman's broader regulatory modernization, the APSR has emerged as a key player, particularly in specific sectors' mandate and functions. The APSR's role includes regulatory oversight, ensuring efficiency, transparency, and competition in the procurement of public services within regulated sectors, e.g., utilities, transport, developing frameworks, issuing regulatory policies, guidelines, and standardized procurement documents for sectors under its purview to ensure they align with national goals like ICV adjudication, serving as an initial forum for hearing and resolving complaints and objections from bidders in certain sectors, providing a specialized alternative to direct court action. Collaboration with Tender Board. The relationship between the traditional Tender Board and the sector-specific APSR is defined by law and royal decree for projects within its sectors. The APSR's regulations may supplement or, in specific cases, provide a tailored framework that operates under the overarching principles of the tender law. It is crucial to check which authority governs a specific tender. Chapter 3, Institutional Roles and Responsibilities. Chapter Overview. A successful tender process relies on a clear segregation of duties and a well-defined institutional hierarchy. This chapter breaks down the key actors within the Omani public procurement ecosystem, explaining their formation, legal authority, specific functions, and how they interact with one another to ensure integrity and compliance from initiation to contract closure. 31 The Tender Board. Formation, powers, and functions. The Tender Board is the apex body overseeing public procurement in Oman. It is not an operational entity but a high-level regulatory and approval authority. Formation. The Tender Board is established by virtue of Royal Decree No. 36/2008. The tender law itself, it is typically chaired by a minister of high standing, e.g., the Minister of Finance, and comprises senior officials from key ministries such as Commerce, Industry, and Economy, along with legal and financial experts. Its secretariat is responsible for its administrative functioning powers, final award approval. Its most critical power is to review and grant final approval for the award of major contracts that exceed specific financial thresholds defined in the law, and its amendments. Approval of method: it approves the use of procurement methods other than open tender, e.g., limited tender, direct assignment, for high-value projects. Policy setting: it issues circulars and decisions that interpret and supplement the tender law, providing guidance to all government entities. Adjudication: it reviews and makes final decisions on objections raised by bidders against awarding decisions made by lower-level committees, serving as a key dispute resolution body within the administrative process. Functions: to convene regularly to review recommendations submitted by government entities to ensure that every stage of the tender process for referred projects complies with the provisions of the tender law and its executive regulations. To protect public funds by scrutinizing the justification for award recommendations and the validity of the evaluation process. 32 Roles of the tendering committee within government entities. Each government unit, e.g., a ministry like transport, or a public authority, must form its own internal tendering committee. This committee is the operational heart of the procurement process within its entity. Formation: formed by a ministerial or departmental decision based on the requirements of the tender law. Usually comprises senior officials from the technical department, engineers, architects, the financial department, the legal affairs department, and the presiding chairperson, often an undersecretary or director general. Roles and functions: oversight: to oversee all tender activities initiated by the government entity from the planning stage until the recommendation of award. Approval of documents: to review and approve tender documents, technical specifications, BOQs, contract drafts, before publication. Evaluation management: to form technical and financial evaluation subcommittees from its members or other specialists and oversee their work. Bid analysis: to review the evaluation reports from the subcommittees, analyze the findings, and ensure the integrity of the process. Recommendation: to make a formal recommendation to either the head of the government entity, e.g., the minister, for contracts within the entity's financial authority, or the Central Tender Board for contracts that exceed the entity's financial authority. Direct orders: to review and approve requests for direct procurement within its delegated financial limits. 33 Responsibilities of the Tender Affairs Department: this department, or unit, acts as the administrative and logistical engine for the tendering committee and the entire procurement process within a government entity. It is the permanent professional staff that ensures continuity. Key responsibilities: preparation, drafting tender documents, advertisements, and clarifications, addenda, based on input from the technical department's publication. Managing the logistical process of publishing tender notices in the official gazette and on relevant platforms. Repository, acting as the official point of contact for bidders, receiving and safeguarding all bids until the public opening. Record keeping, maintaining meticulous archives for every tender, including all correspondence, submitted bids, minutes of meetings, and evaluation reports. This is crucial for transparency and for handling any future objections or audits. Coordination: coordinating the schedules for tender committee meetings, site visits, and bid opening ceremonies. Communication: issuing official letters to bidders, e.g., invitation to tender, requests for clarification, notification of award or rejection. 34 The financial controller's role: the financial controller, or the financial oversight department, acts as an independent financial watchdog within the government entity. Their role is to ensure all procurement activities adhere to financial regulations and protect public funds. Key responsibilities: budget verification, the first checkpoint verifying the availability and correctness of the budget allocation for the tender before it is even announced. Process oversight, attending bid opening ceremonies to verify the process and signing the official minutes to attest to its correctness. Financial scrutiny, reviewing the financial aspects of the evaluation process, ensuring the calculated prices of the lowest bidder are accurate and error-free. Contract compliance, scrutinizing the financial terms of the draft contract before it is signed, including payment schedules, advance payment terms, and securities payment approval, reviewing and approving all interim and final payments to the contractor against the signed contract, ensuring they are justified, within the agreed terms, and that any deductions, e.g., for liquidated damages, are applied. Audit trail, providing a continuous audit trail from budget allocation to final payment. Ensuring every expenditure is lawful and properly documented. Their signature is often required for any financial transaction related to the tender. Chapter 4, Initiation and Planning for the proposed Encyclopedia. Part 2, the Tender Life Cycle, Pre-Contract Phase, Chapter 4, Initiation and Planning. Chapter Overview. The initiation and planning phase is the most critical stage of the entire tender process. Decisions made here determine the project's success, fairness, and efficiency. This chapter details the foundational steps a government entity in Oman must take, from identifying a need to publishing a tender, ensuring every action is grounded in the principles of the tender law and strategic national interest. 41 Needs assessment and project definition. This is the conceptual origin of any tender. A poorly defined need leads to ambiguous tenders, unsuitable bids, and project failure. Identifying the requirement, the process begins with a user department, e.g., the Directorate General of Education needs new schools, identifying a specific need to achieve its strategic objectives. Feasibility studies. For large projects, a preliminary study may be conducted to assess technical, economic, and operational viability. This helps justify the investment of public funds. Stakeholder consultation, engaging all relevant parties, end users, technical departments, maintenance teams, finance, to gather input and ensure the project definition is comprehensive. Output, the project brief. A formal document is produced that clearly outlines objectives, what the project aims to achieve, scope, the boundaries of the work, including what is included and, just as importantly, what is excluded. Key deliverables, the tangible outputs, e.g., a constructed building, 500 computers, a detailed design report. Strategic alignment, how the project supports broader goals like Omanization, in-country value, ICV, and technology transfer. 42 Budget allocation and financial approval. No tender can be launched without secure funding. This step ensures financial governance and prevents the commitment of public funds without proper authorization. Cost estimation, based on the project brief, the technical department prepares a preliminary cost estimate. This can be based on similar past projects, market rates, or expert judgment. Budget identification, the entity's finance department identifies the specific budget line item from which the project will be funded. The budget must be officially approved and available within the fiscal year's allocations. Internal approval, the estimated cost and budget source require formal internal approval from the head of the entity or an authorized financial delegate. This is often a mandatory prerequisite before the Tender Affairs Department can begin any work. The role of the financial controller, the entity's financial controller verifies the availability and adequacy of the budget, acting as a crucial check to prevent overspending and ensure fiscal responsibility from the very start. 43 Preparation of tender documents, terms of reference, specifications, BOQs. This is the translation of the project concept into a formal, legally sound invitation for bids. The quality of these documents directly dictates the quality of the responses and the success of the ensuing contract. The tender dossier, the complete set of documents, typically includes invitation to tender, a formal letter outlining the basic details, instructions to bidders, the legal and procedural rules governing the bidding process, submission requirements, evaluation criteria, and contract terms. These are often standard templates provided by the tender board. Technical specifications, performance-based, focus on the desired function and outcome, allowing bidders flexibility in how they achieve it, generally preferred for encouraging innovation. Descriptive/design-based, precisely describe the materials, dimensions, and methods to be used. Must be used carefully to avoid being overly restrictive and limiting competition. Bill of quantities, BOQ, a tabular schedule itemizing all anticipated work, materials, and services with quantities and units of measure. Bidders enter their unit rates and total prices here. It forms the basis for payment during the contract. Accuracy is paramount to avoid disputes. Terms of reference, TOR, used primarily for consultancy and service contracts. They define the objectives, scope of work, activities, tasks, deliverables, timelines, and background information for the service required draft contract, the full proposed contract, including all clauses related to payments, penalties, termination, dispute resolution, and ICV obligations. 44 types of tenders: public, limited, direct order, and two-stage tenders. The Omani tender law specifies various procurement methods, each with strict conditions for use. Choosing the correct type is a vital planning decision. Public tender. Description: the default and most transparent method. The tender is publicly advertised in the official gazette and local newspapers, allowing any qualified bidder to participate when used. For most procurements, especially those above a certain value threshold, it ensures maximum competition and adherence to the principles of transparency and equality. Limited tender. Description: invitations are sent to a pre-selected shortlist of contractors or suppliers, without public advertisement when used, as per Law 36/2008 for specialized work/goods that only a few limited suppliers can provide. For low-value contracts where the cost of a public tender is disproportionate. In cases of extreme urgency where public advertisement timelines would cause severe detriment. Requirement: requires strong justification and prior approval from the tender board. Direct order. Description: awarding a contract directly to a specific supplier without any competitive process when used, under strict conditions when there is only one possible source for the required good or service, a monopoly, for genuine emergencies, e.g., natural disasters, where any delay would be dangerous. For extensions of existing contracts where a change of contractor would cause significant disruption or cost. Requirement: this is the exception, not the rule. It requires the highest level of justification and must be approved by the tender board or the head of the entity, depending on the value. Two-stage tender. Description: a method used for complex projects where technical solutions may vary. Stage 1. Bidders submit technical proposals without prices. These are evaluated and clarified. The entity can discuss and refine the specifications with bidders. Stage 2. Approved bidders from Stage 1 are invited to submit financial bids based on the finalized technical specifications when used. For large, complex engineering projects, IT systems, or projects where innovation is desired and the scope cannot be fully defined at the outset. Advantage: allows for early contractor involvement and leads to a more defined and cost-effective final proposal. Chapter 5, Invitation to Tender. Chapter Overview. This chapter covers the critical phase where the planned procurement is formally presented to the market. It details the legal requirements for publicizing the opportunity, the mechanism, bid bond, used to ensure serious participation, the interactive processes for clarifying requirements, and the formal procedures for managing changes to the tender documents. The stage sets the tone for the entire competition and is fundamental to maintaining transparency and fairness. 51 Announcement and publication in the official gazette and other media. The publication of a tender is a formal legal act designed to ensure maximum visibility and equal access to information for all potential bidders. Mandatory publication in the official gazette. Primary channel: publication in the official gazette, known as Al-Jarida al-Rasmiyya, is a legal requirement for all public tenders under Omani law. This publication serves as the official legal notification to the public. Content: the announcement must include essential information, the government entity's name, the tender title and reference number, a brief description of the work supply/service, the value of the tender, security, bid bond, the deadline and address for submission, and the date, time, and location of the public bid opening. Publication in other media, newspapers. Tenders are often advertised in widely circulated local Arabic and English newspapers, e.g., Oman Observer, Al Watan, to ensure broader reach within the business community. Government e-portals. Increasingly, tenders are published on the official online portals of the issuing government entity and central platforms like the Tender Board's website or the Oman Procurement Platform, if applicable, which enhances accessibility and efficiency. Key principle: transparency. The dual-channel approach, official gazette and other media, is a direct application of the principle of transparency, ensuring that no potential bidder is disadvantaged by a lack of information about the opportunity-52 tender security, bid bond types, value, and validity. The bid bond is a fundamental risk management tool for the government, designed to ensure that bids are serious and committed purpose, to compensate the government for the costs and delays incurred if the winning bidder refuses to sign the contract or fails to provide the required performance security to deter frivolous or non-serious bidders from participating. Types. Unconditional bank guarantee. This is the most common and preferred type. It is a guarantee issued by a reputable local Omani bank on behalf of the bidder, payable on first demand by the government entity without the need to prove default or loss. Certified check. A check from the bidder's account, certified by their bank to ensure the funds are available and blocked. This is less common for large values. Cash deposit, highly uncommon and generally discouraged for security and practical reasons. Value. The value is a percentage of the tender's estimated value, as stipulated in the tender law and its executive regulations. It is typically 1% to 5% of the tender value. The exact percentage must be clearly stated in the tender documents. Validity. The bid bond must remain valid for a period exceeding the bid validity period by a certain number of days, e.g., 30 days. This ensures the government is covered during the entire evaluation period and while finalizing the contract with the winning bidder. A bid is typically declared non-responsive and rejected outright if it is not accompanied by a valid tender security in the exact required form and amount. 53 Pre-tender meetings and site visits. These are interactive sessions held after the tender is published but before the bid submission deadline to ensure all bidders have a clear and common understanding of the project's requirements and context. Purpose, to clarify any ambiguities in the tender documents, to allow bidders to visit the project site to assess ground conditions, access, logistics, and any existing structures. For rehabilitation projects, this allows them to prepare accurate and informed bids, to answer questions from potential bidders in an open forum, ensuring all receive the same information simultaneously. Process. The meeting and/or site visit is announced in the tender documents. Attendance may be mandatory or optional, but it is always highly recommended for bidders. Minutes of the meeting are recorded, detailing all questions asked and answers provided. These minutes are then formalized into an addendum, C54, and distributed to all parties who purchase the tender documents, maintaining fairness. 54 Handling queries and issuing addenda. This is the formal process for managing changes and clarifications to the tender documents after publication, ensuring a fair and transparent flow of information to all bidders. Handling queries. Bidders are instructed to submit any questions or requests for clarification in writing, often via email or formal letter, to the designated contact in the Tender Affairs Department. The entity must respond to these queries. However, to maintain fairness, the response is not sent only to the inquiring bidder issuing addenda. Any clarification, modification, or correction that materially affects the tender requirements is compiled into a formal document called an addendum distribution. The addendum is sent to all registered bidders who have purchased the tender documents. Proof of distribution is maintained legal effect. An addendum becomes a legally binding part of the tender documents. Bids must comply with the addendum's instructions. Deadline impact. If an addendum introduces significant changes, the tender submission deadline may be officially extended by the entity to give all bidders sufficient time to revise their proposals. This extension is also communicated via an addendum. This rigorous process ensures the principle of equal treatment is upheld, as no single bidder gains an informational advantage over another. Chapter 6, Bid Submission and Opening. Chapter Overview. This chapter details the critical and highly procedural phase where the market's offers are formally received and publicly unveiled. The process is designed to be a cornerstone of transparency, ensuring that all bids are treated with absolute equality and that no manipulation can occur between submission and opening. Strict adherence to these procedures is mandatory to maintain the integrity of the entire tender. 61 Rules for bid preparation, sealing, and submission. The tender documents provide explicit, non-negotiable instructions for preparing and submitting bids. Failure to comply renders a bid non-responsive and leads to its immediate rejection. Bid preparation. Language. Bids must be prepared in Arabic, unless otherwise specified in the tender documents, e.g., for international tenders, English may be acceptable, All supporting documents in other languages must have a certified Arabic translation format. Bidders must use the forms and schedules provided in the tender documents. No alterations to the structure should be made. Signing the bid must be signed by a person with due authority to legally bind the bidding company. The power of attorney or commercial agency documentation must be submitted if signed by a representative. 2 envelope system. For tenders involving both technical and financial proposals, the mandatory 2 envelope system is used. Envelope 1 contains the technical proposal, devoid of any pricing information. Envelope 2 contains the commercial offer, priced bouquet, financial schedules. No alterations, erasures, overwriting, or omissions must be initialed by the person who signed the bid. Uninitialed alterations can be grounds for rejection. Sealing and marking, clear labeling. Each sealed envelope must be clearly marked with the tender reference number and title, the name and address of the bidder, the words technical proposal or financial proposal as applicable. A warning: do not open before date and time of bid. Opening. Double sealing. Both envelopes are then placed into a larger outer envelope, which is also sealed and marked with the same information. This prevents premature access to any part of the bid submission. Authorized location. Bids must be delivered to the exact location specified in the tender documents, typically the office of the Tender Affairs Department within the issuing government entity. Official receipt. Upon submission, the bidder should receive a dated and signed receipt as proof of submission. It is the bidder's responsibility to obtain this receipt. 62 Deadline adherence and late bid procedures. The submission deadline is a strict, inflexible cut-off point enshrined in law to ensure absolute fairness. The deadline, the exact date and time for the final submission of bids are explicitly stated in the tender advertisement and documents. This deadline is considered sacrosanct. Late bids, automatic rejection. Any bid delivered to the designated location after the exact deadline specified is classified as a late bid procedure. Late bids are not accepted. The Tender Affairs Department must refuse to receive them. If a late bid is physically delivered, it must be returned unopened to the bidder or kept sealed and separately marked as late with the time of receipt recorded. Legal basis. This strictness is mandated by Article 45 of the Tender Law, Royal Decree 36/2008, and its executive regulations. It eliminates any discretion or potential favoritism in accepting delayed submissions and protects the integrity of the process. No exceptions are permitted, regardless of the reason for the delay. 63 The public bid opening process, minutes and documentation. This is a fundamental public ceremony that demonstrates the principle of transparency. It is the first time the bids are opened, and it is done in a forum where all participants can witness the process. The ceremony. Timing. The bid opening is held immediately after the submission deadline or at a time specified in the tender documents, but always on the same day. Venue and attendance. It is conducted as a public meeting at the government entity's premises. Attending bidders or their representatives are allowed to be present and witness the proceedings. Presiding committee. The opening is presided over by the tender committee or a designated opening committee, invariably in the presence of the financial controller or a representative from the financial department. The process. 1. Announcement. The committee announces the names of the bidders who have submitted proposals on time. 2. Initial check. The outer envelopes are opened, and the inner envelopes, technical and financial, are checked for proper sealing and marking. 3. Two-stage opening. For 2 envelope bids, only the technical proposal envelopes are opened. The financial envelopes remain sealed and are immediately secured in a safe. The financial offers of bidders who pass the technical evaluation will be opened later at an announced date. For single-stage bids, both technical and financial details are read aloud. For reading aloud, the following details from each bid are read aloud for all to hear: the name of the bidder, the presence and value of the tender security, bid bond, any alternative proposals, and any discounts offered for single-stage bids. The total bid price is announced. Minutes of bid opening. Documentation. A formal report, known as the minutes of bid opening, is prepared during the ceremony. Content. The minutes meticulously record everything that occurs: the names of attendees, the names of all bidders, the information read aloud from each bid, and any observations made about the submissions, e.g., bid security was missing, document not signed, signatures, The minutes are signed on the spot by all members of the opening committee and the attending financial controller. This document becomes a key part of the official tender record and is essential for transparency. A copy is often made available to attending bidders upon request. Chapter 7, Bid Evaluation and Award. Chapter Overview. The evaluation and award phase is the core of the tender process, where submitted bids are scrutinized and the winning bidder is selected. This chapter details the meticulous, multi-stage process mandated by Omani law to ensure the selection is objective, fair, and results in the best value for public funds. It balances the cardinal principle of awarding to the lowest price with the critical need for technical compliance and quality. 71 Technical evaluation, compliance and responsiveness. This is the first and most crucial filter. A bid must be fundamentally sound before its price can even be considered. Purpose: to verify that the bidder has offered a solution that fully meets the mandatory requirements outlined in the tender documents. Process: a technical evaluation committee, often comprising internal and external subject matter experts, reviews each technical proposal against the criteria. Key checks: administrative compliance, confirming all required documents are submitted, e.g., bid security, power of attorney, registration certificates, CVS of key staff. Technical responsiveness, assessing if the offered goods, works, or services conform to the specified standards, specifications, and performance criteria. This includes checking for unacceptable deviations or alternative proposals. Outcome: bids are classified as either substantially responsive, the bid meets all mandatory requirements, it proceeds to the next stage; non-responsive, the bid contains a material deviation, omission, or failure to meet a key specification, it is rejected and does not proceed to financial evaluation. 72 Financial evaluation, scrutiny of prices and calculations. Only the financially viable offers from technically compliant bidders are evaluated. Purpose: to determine the complete and accurate cost of each responsive bid. Process: a financial evaluation committee, often including the financial controller's office, meticulously checks the commercial offer's key activities: arithmetical verification, checking for errors in multiplication and addition in the bill of quantities, BOQ. Corrections are typically applied as per the method stated in the tender documents, e.g., the unit price prevails over the total. Completeness, ensuring all items in the BOQ are priced. Unpriced items may be considered included in other prices or lead to rejection. Identification of abnormalities, investigating very high or very low unit prices that might indicate a front-loaded payment schedule or a potential future claim. Currency conversion, if applicable, converting all prices to Omani Rials, OMR, using the official exchange rate stated in the tender documents. 73 The principle of awarding to the lowest valid bid. This is the default and foundational rule for award decisions in Omani public procurement. The rule: the contract must be awarded to the bidder who has submitted the lowest priced bid that is both technically compliant and financially correct. Valid bid definition: a bid is considered valid only after it has successfully passed all stages of technical and financial evaluation without any material deficiency. The lowest price is irrelevant if the bid is not valid. Objective justification: this principle provides an objective, quantifiable, and defensible basis for the award, minimizing subjectivity and the risk of challenges. 74 Exceptions to the lowest bid rule. Best value procurement. The tender law recognizes that the lowest price is not always the most economically advantageous option. Consultancy and intellectual services, for contracts where quality and expertise are more important than price, e.g., engineering design, financial advisory, management consulting, the award is based on quality-based selection, QBS, process. Proposals are evaluated on technical merit, e.g., methodology, team experience, understanding of the task, and assigned a score. Only the top-ranked technical proposers are invited to submit financial proposals. The contract is often negotiated with the highest-ranked technical bidder. Best value procurement. In some cases, a scoring system is used where technical criteria, e.g., quality, energy efficiency, life cycle cost, are weighted, e.g., 70%, against the financial offer, e.g., 30%. The contract is awarded to the bidder with the highest combined score, not the lowest price. 75 Post-qualification of bidders, a critical due diligence step to verify the highest ranked bidder's actual ability to perform the contract purpose, to confirm that the apparently successful bidder possesses the financial, technical, and managerial resources they claimed in their bid. Timing, conducted after the evaluation is complete and a lowest/best bidder is identified, but before the official award is recommended. Checks include financial capacity, verifying audited financial statements, bank references, and creditworthiness; technical capability, visiting existing facilities, verifying similar past project experience, and checking ownership of key equipment; legal compliance, confirming valid commercial registration, tax clearance certificate, and Chamber of Commerce membership. Consequence of failure: if the bidder fails post-qualification, they are rejected, and the process moves to the next lowest ranked bidder. 76 Preparation of the evaluation report and recommendation. The entire evaluation process must be meticulously documented to ensure transparency and defendability. The evaluation report, this is a comprehensive document that serves as the official record of the entire process. It includes a summary of all bids received and open details of the technical and financial evaluation, including reasons for rejecting any non-responsive bids, the detailed calculations and comparisons of evaluated prices, the results of the post-qualification exercise, the clear recommendation for award, naming the successful bidder, and the final evaluated contract price approval. The report is signed by all members of the evaluation and tender committees, then submitted to the head of the procuring entity for endorsement. 77 Obtaining the final award approval from the tender board. The procuring entity does not have the final authority to award all contracts. Delegated authority: the head of a ministry or government unit may have the authority to award lower value contracts as defined by financial thresholds in the tender law. Tender board approval: for high value contracts, as per the thresholds set by royal decree, the evaluation report and recommendation must be submitted to the Central Tender Board for review and final approval. The board's role: the tender board scrutinizes the entire process to ensure strict compliance with the law and regulations only. Upon their issuance of an award letter or no objection certificate, can the procuring entity proceed to inform the successful bidder and sign the contract. Chapter 8, Objections and Grievances. Chapter Overview: a transparent and fair procurement system must include a robust mechanism for challenge and redress. This chapter outlines the formal process through which aggrieved bidders can raise objections against decisions made during the tender process. Understanding these procedures is critical for both bidders, to protect their rights, and for government entities, to ensure their decisions are defensible and compliant with the law. 81 The right to object. Procedures and timelines. The Omani tender law grants bidders a specific legal right to challenge decisions, but this right is bound by strict procedural rules and very tight deadlines. Legal basis: the right to object is enshrined in Article 56 of Royal Decree No. 36/2008, the tender law, and its executive regulations. This legal guarantee is a key component of the principle of transparency. Grounds for objection: a bidder can only object on specific, justified grounds, such as a procedural error or violation of the tender law or the tender documents, the evaluation process was not conducted fairly or objectively, the award decision did not follow the stated criteria, e.g., not awarding to the lowest valid bidder without justification, perceived bias or conflict of interest. Strict timelines. Notification period: the objection clock starts ticking from the moment the bidder is notified of the award decision or the action they are challenging. Submission deadline: the bidder must submit a formal written objection to the tender board, for contracts under its purview, or the head of the concerned government entity within a very short period, typically 10 days from the date of notification. This deadline is absolute, and late objections are not considered formal. Procedure: the objection must be submitted in a written, formal letter. It must clearly state the tender number, the subject of the tender, and the precise reasons for the objection, supported by all relevant documents and evidence. The objecting bidder often must provide a financial guarantee, e.g., a bank guarantee of 1% of the tender value, to prevent frivolous claims. This guarantee is refunded if the objection is upheld but may be forfeited if it is deemed frivolous. 82 Reviewing and Deciding on objections, the reviewing authority must conduct a thorough and impartial review of the objection to ensure the integrity of the process. Reviewing authority: for major tenders, the tender board is the primary authority for reviewing objections. For lower value contracts, the head of the procuring entity may be the initial reviewer. The review process: 1. Acknowledgement: the authority acknowledges receipt of the objection. 2. Notification: the procuring entity against whom the objection is raised is formally notified and asked to provide a detailed response and the complete tender file for review. 3. Examination: the tender board, or a dedicated committee, meticulously examines the objection, the entity's response, and the entire record of the tender process, evaluation reports, minutes, etc. 4. Decision-making: the board deliberates to determine if the objection has merit, i.e., whether a procedural violation occurred that could have affected the outcome of the tender. Possible decisions: rejection: the objection is dismissed if it is found to be without merit, frivolous, or submitted outside the legal deadline. Upheld: if the objection is upheld, the tender board can take several actions: cancel the award decision and recommend a re-evaluation of bids, cancel the entire tender process and order a retender, direct the entity to correct a specific procedural error. The decision is communicated in writing to both the objecting bidder and the concerned government entity. 83. Recourse and appeals process: if a bidder is unsatisfied with the decision of the tender board on their objection, they have a final avenue for recourse within the judicial system: appeal to the judiciary authority, the competent court, typically the administrative circuit of the primary court in Oman, has jurisdiction over disputes related to administrative decisions, including tender awards. Grounds for appeal: a bidder can appeal the tender board's decision on grounds such as an error in law, a violation of procedure, or if the decision was arbitrary or capricious. Timeline: the appeal to the court must also be filed within a specified, short period from the date of being notified of the tender board's decision on the objection. Court's role and powers: the court conducts a judicial review of the process. It does not re-evaluate the bids itself but examines whether the administrative authority, the tender board and the procuring entity, acted within its legal powers and followed due process. The court has the power to uphold the tender board's decision, cancel the tender board's decision and the subsequent award, order the procuring entity to take specific actions, e.g., rerun the tender. The court's decision is legally binding on all parties. Suspensive effect: filing an objection with the tender board usually does not automatically suspend the tender process or the signing of the contract. However, filing an appeal with the administrative court can have a suspensive effect, potentially halting the award until the court makes a preliminary decision. This prevents irreversible actions from being taken during the legal challenge. Chapter 9, Contract Formation and Execution - Part 3, Contract Management, Post-Award Phase. Chapter 9, Contract Formation and Execution. Chapter Overview: the award decision marks the transition from the competitive tender phase to the contractual relationship. This chapter details the critical steps of formally establishing this legally binding agreement between the government entity and the successful bidder. It covers the official notifications, the finalization of security instruments, the core components of the contract itself, and the various types of contractual arrangements used in Omani public procurement, setting the stage for all subsequent management activities. 91. Issuance of the award letter and notice to proceed: this is the formal commencement of the contractual relationship, though the full contract may not be signed immediately. Award letter: purpose, a formal, official written communication issued by the government entity to the successful bidder, informing them of the award decision. Content: it specifies the tender reference, the awarded value, and any specific conditions that must be fulfilled before the contract can be signed, e.g., providing performance security, signing the contract document. Conditional nature: the award is typically conditional upon the successful fulfillment of these next steps. It is not yet an unconditional permission to begin work. Notice to proceed, NTP: purpose, a separate, distinct document that gives the contractor the formal authority to mobilize resources, occupy the site, and commence work. Timing: the NTP is issued after the contract has been duly signed by both parties and the contractor has provided all required contract effective securities, especially the